are you? Today, we are going to celebrate National Constitutional Day. The meaning is National Law Day, November 22nd, 2022. I'm very happy to inform this Law Day because basically I'm a lawyer and also law professor. Okay. Hello, viewers. Please enjoy without any interrupting in your minds because our framers of the constitution given Indian constitution. Why? Because this is a lengthiest constitution in our world. Many of the countries also referred in our constitution in their court, in international court also. This constitution books also verified because this is a common law, because this is a written constitution, because written constitution, because written constitution and unwritten constitution is available, but in our constitution is a lengthiest one and written constitutions. I just wanted to discuss in first stanza is preamble of the Indian constitutions. So the preamble of the Indian constitution is a very clear one. Why? Because the preamble is indicated in our constitution is we, the people of India. Yes, we, the people of India. We are not a foreigner because we are basically born from Indian nation, Indian land. So we should interact with the people all over the world, those who are residing all over the world, Indians. We should share the in-depth, inner celebration to the peoples for the purpose of celebrating the National Constitutional Day. So the preamble is indicated we, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic and to secure to all its citizens is clearly indicated in the first stanzas. And also explain about justice, social, economic, and political. Liberty of thought, we don't think about any stations, no entrance of thought. Our Indian constitution given to all the people liberty of thought freely and free to express expression and belief, faith and worship. Those who are coming from many parts of the religious parts. So there is no discrimination religious. And Article 15 clearly explain about no discrimination, caste, okay, religious, gender, and etc. So, equality of status of opportunity under Article 14 given to our people through the Indian constitutions. Article 14, equality before law. And Article 16 clearly explained about equal opportunity in public employment. That meaning is our Indian constitution framers of the framers framed clearly to give opportunity to the people, equal opportunity in public employment in central government and particular respect to state government also. You know very well the central government recruited by the UPSC, in state government respect to state government from the public service commissions in particular individual states. For example, Tamil Nadu Public Service Commission, Andhra Public Service Commissions, so etc. Kerala Public Service Commissions. But in unitarily central government recruited, the system is UPSC system, Union Public Service Commissions. So the many opportunity is coming from in our constitutions. And also the preamble explain about equality of status and also and promote among them all fraternity, assuring the dignity of the individual person. You should maintain the dignity. Okay, nobody will defaming you. And the unity, this is very important thing. Unity is a strength. Okay, without unity, what happened? There is no peaceful atmosphere in our country. That is why in preamble indicated unity and integrity of the nations. This is very important, integrity of the nations. And also in our Constituent Assembly, the same year, not same year, the same month, same day. That meaning is 20th, 26th day of November in the year of 1949, do hereby adopt, enact, and give to ourselves the Constitution. So this is what explain about the Constitution. So the preamble is the lengthiest one and also indicated introduction part of the Constitution. So and also many jurists also explain about in our Constitution. Aristotle, Dicey, Austin, and Casey Bear, Coley, many other jurists, international jurists also explain about Indian constitutions. And also the Constitution is the law of the land, and also it is the known as national law or municipal law. And also in our Constitution is a supreme law of the law, and also which determines the governmental machinery of a state comprising of the executive, legislature, and judiciary, because we have three organs of the government, three organs of the main machinery of the Constitution. Explain about executive, legislature, and judiciary. Legislature in central, in parliament, in state legislatures. Okay, so these are all available in our Constitution given to the people, and written Constitution a country is very form of single or several documents. In our Constitution, a single book and several constitutions, several documentary, because this Constitution is derived from the various part of the various part of world. Okay, that meaning is extracted from the various countries' constitutions. And only thing, the main thing, the drafted committee is available. The head of the drafted committee is Dr. B.R. Ambedkar, is a very greatest person. He served a very elaborated work in our nations. So now November 26, 1949, the Constitution Assembly of India formally adopted the Constitution of India. So it came to force in the year of 1950 November, sorry, in the year of 1950 January 26. So the framers of the Constitution framed 1949, but it will be drafting committee taken the during times is nearly 2 years, 11 months, 18 days. Okay, so the aim to bring awareness about the importance of the constitutions, and Dr. B.R. Ambedkar, his name is elaborated is Bhimarao Ramji Ambedkar. His original name is Bhimarao Ramji Ambedkar. So he was a chairman of the drafting committee, and also is considered to be the chief architect of the Constitution of India, and is also called the father of the Indian constitutions. The Constitution of India was drafted by the members of the Constituent Assembly. So the written principles and precedents of the government of India, it frames fundamental political principles. This is main one, and also procedures, rights, directive principles, restrictions, restrictions, and duties of the government. That meaning is and citizens of the country. Fundamental duties is available under Article 51A of the Indian Constitutions. So the Constitution of India declares the country a sovereign, secular state, socialist, and democratic republic. So it assures its citizens equality, liberty, and justice. And also the preamble brief statement with records of the aims and aspiration of the peoples of India. And also the Constitution of India reads, I already explained about we the people of India. Okay. So the main, this word is very important, explained clearly in our constitutions. So how the national law celebrations is very important. Here, the major goal, that means the main goal of commemorating Law Day, according to the president of the Supreme Court Bar Association, is to honor the fundamental ideas that served as the basis for the constitutions: the independence of the courts, the rule of law, and the legal professions are some example of these concepts. And also, I just wanted to give history of National Law Day because this is very important topic today. That's why I'm discussing with the constitution elaborately, because I don't want to teach with the constitution law, because many viewers are watching in our video, because I just wanted to give what is the meaning of the constitution, how the importance of the constitution, why we are celebrating the constitutions, right? So the same day, the 26th November 1949, the Constitution Assembly of India formally adopted the constitution. You know very well, we discussed the earlier part at the time of initial stage. So we have, apart from preamble, our Indian constitution is a flexible and rigid constitutions, and also unitary and a federal constitution nature. And also the salient features of the our Indian constitution is available, because the lengthiest constitution we discussed earlier, because at the time of passing the drafted committee of our Indian constitution, only 395 articles. These articles divided into 22 part and 8 schedule only. Now this article is amended, is it converted into nearly 448. Okay, articles is available. So in the here, constitution has been amended from time to time by inserting and omitting certain provisions articles. The latest amendment, as on in the year of January 1st, 2015, is the Constitution, that meaning is 99th Amendment Act 2014. There are nearly nearby 400, 420 nearby. After that, now presently 448 articles. So in the year of 2015, our article is divided into parts, 25 parts and 12 schedules. So in our constitution is a quasi-federal, quasi-federal in nature, but unitary law, because our country may be unitary or federal. In unitary constitution, powers are centralized in central government only. Example in England, UK, no federal constitution. That is why our constitution is a federal nature, but not a federal constitutions. Whenever we need, the central government will enact the parliament having power to enact the law based on this our Indian constitution only. Without a constitution, there is no law will be enacted by the any peoples. The only legislature having power to enact the law. Okay, and also the state legislature enacted the law with the permission from the central. Okay, so we have fundamental duties explained about under Article 51A. Fundamental rights is available under Article from 12 to 35 of the Indian constitutions. So in the year of 1976, 42nd Amendment specifically imposed on the citizens certain fundamental duties, and also requires the citizens to observe certain basic norms of democratic conduct and behavior. And also in our constitution is a single citizenship. Okay, we have judicial review, because in our judicial department is a independence of judiciary system under Article 124 of the Indian Constitutions, because the judges of Supreme Court and High Courts are appointed by the President. The Constitution 99th Amendment Act 2014 provides for formation of National Judicial Appointments Commissions for the purpose of recruitment of the judges. So our article is amending day by day from time to time by the legislators with the, with the welfare of the peoples. So further, Article 32 and Article 226 confer on the Supreme Court and High Court. If you are using under Article 32 to file before the Supreme Court, and with the help of Article 226 to file before the High Courts, the power of judicial review to examine the constitutional validity of a law passed by Parliament or state legislature. This is a very big provision is available. Very important thing, because based on this article, the judicial remedy will get, this is a basic rights of the our people. And also in our constitution is a both rigid and flexible, and also how the features of the constitution is explained: the distribution powers, supremacy of the constitution, rigidity and authority of the courts, and dual policy system. Okay, so we come to the point. The preamble is a very important thing, because the preamble already indicated, I discussed the justice, liberty, equality, fraternity. Okay, and also justice is explained about social, economic, and political. Liberty meaning is liberty of thought, liberty of expressions, liberty of belief, liberty of faith, liberty of worship. Those who are coming from different kinds of religious peoples, that individual person will worship individual rights. Okay, nobody will disturb. So in our constitution, given opportunity to the people to worship any god, nobody disturb, right? So and also fraternity, the word is indicated. Fraternity is very important thing, assuring the dignity of the individual and unity and integrity of the nations. This integrity of the nation is very important role. Okay, the word fraternity means the spirit of brotherhood. We are all brothers and sisters. Okay, there is no discrimination between the peoples, and a feeling that all the people are children of the same soil, the motherland. So, according to Dr. B.R. Ambedkar, fraternity implies a sense of common brotherhood of all Indians. So, the Indian Constitution makes no provision which reflects fraternity as an object. So, why this role of preamble? The preamble is a interpretation of the Constitution and also introduction part of the Constitution. We have the Constitution explained about citizenship, how the peoples are migration to country and place to place, and elaborately explained under Article 5 to 11 of the Indian Constitution. Article 1 to 4 explained about union and the territories, how the jurisdiction area is available, how the formation of the uh, states, how the annexation, how deletion from the parliament area with the help of simple majority. So many procedure is available for the purpose of how the government will be function based on this constitution. If any violating of the any one of the law imposed by the government, that meaning is directly from state policy. If any states having policy, and if they are making any law, that particular law in force is violating the particular individual persons or any other individual citizens, that automatically what happened, the citizen having rights, that is basic rights, that is fundamental rights, is available based on this our Indian constitution given to the people to claim, to claim. How the claim? Article 12, from 12, 13, 14, 15 up to 35 article is available. Based on this basic rights is available, we can utilize. So, and also some restriction is available. Okay. So Article 14 is equality before law, saying that there is no poor, there is no bigger, there is no professional higher cadre or any peons, whoever it may be, all the peoples of the land is equal to before law. But some privileges is available. We know privileges given by the constitution to the people under Article 105, subclass 1 and 194 of subclass 1. 105 subclass 1 given to the people of the parliamentary members, privileges and immunities. Freedom of speech and expression is available instead of the parliamentary area, and also arrest procedure is available. The procedure is some extended limited is available based on these constitutions. In state legislatures, given to the opportunity, the state legislatures that legislature of the assembly peoples given opportunity with the help of under article 194 subclass 1. So the freedom of speech and expression will not abstract to the peoples. They free to speak, free to discuss in the legislature area. Why? Because that area is a negotiation and discussing area. Then only the enacting the law for the purpose of the welfare of the people. Okay, and also Article 19 subclass 1 is clearly explained about Article 19.1 A, freedom of speech and expression. Okay, freedom to speech, express freely without any hesitation, without any obstacle, without any hindrance from the people. But reasonable restriction is available under Article 19 subclass 1. So based on this Article 19, subclass 1 clearly explain about in our people, given opportunity the people, 19.1 clearly explained. So based on this 19 subclass 1 is a very important provision of our people, freedom of speech. So based on this article, we are utilizing free to talk, free to speech, free to express. For example, what my mind is think about me or any other person, free to talk, but some restrictions is available. So our constitution gave opportunity the reasonable restriction because nobody violating the fundamental rights. So freedom of assembly also available under Article 19, subclass 1B. Freedom to form association also given to the people under Article 19, subclass 1C. Freedom of movement also given to the people, Article 19, subclass 1E. And freedom of profession, any profession, lawyer, doctors, any other profession, occupations, trade of business under Article 19, 1G. But one provision, Article 19, 1F is deleted by the our parliament peoples. Why? Because the 19.1F was given to the people, that is basic rights, that is fundamental rights to the property. What happened? The 42nd Amendment in the year of 1976, the basic rights is converted into ordinary rights because the heading Article 300A. The framers of the legislatures planned if any public utility of the particular land. So give compensation to the particular citizens and acquire the land and give the reasons and give the compensations. The three columns is available. If the public utility is satisfied, then the government will take the acquire the land from the individual person. That is why the F was deleted by the legislators amending the 42nd Amendment in the year of 1976. So now the property is a ordinary rights, but the government will give reason if that if they are not providing proper reason, public utility not given to the people, the violating the fundamental rights. Automatically, those who are aggrieved person to file the case against the government, the court will be take necessary action against particular provisions. Okay, then only the court will interfere. Otherwise, if violating of the fundamental rights, that particular time only court will intervening the intervening and ask any other question to the government. Otherwise, court will not ask any other questions, right? So this is a provision based on this fundamental rights. We have Article 32. Article 32 provision is available. 12 to 35 is available. So based on this article, those who are aggrieved person to go to the court. Okay. So 19 subclass 2 reasonable restriction I explained about. Same 19(1)(b), 19 subclass 3, 19(1)(c), 19 subclass 3, 19(1)(e), subclass 4, 19 subclass 4, and going on up to 19 subclass 5. Okay, these are all restrictions. Reasonable restriction is available. So, and main thing, what is the main reason of expression is broad freedom of speech is expression is helps an individual to attain self fulfillment, and also it assists in discovery of truth. If I am speaking truly, somebody will assessing clearly. Okay, that is why our constitution gave to the people freedom of speech, and also it strengthened the capacity of the individual in participating in decision making. Right? If I am nervous, what can I do? I cannot able to express my thoughts. That's why our constitution gave opportunity to the people. You can utilize the fundamental rights. 19 subclass 2 is reasonable restrictions that nearly 8 grounds is available. Number one is the sovereignty and integrity of India. Number two, the security of the state. Number three, the friendly relations with the foreign states. Number four, public order. Number five, decency or morality. Number six, in relation to contempt of court, defamation, incitement to an offense. So, if any one of the person having rights freedom of speech, what happened? They should follow some principles. If any one of the person violating the speech, violating the particular article without the limit, what happened? Defaming the particular persons, what happened? Automatically law will be take against you, right? This provision 19 subclass 2 is restrictions punished by the law. Those who are violating the 19 subclass 2, automatically law will be punished. This provision is available. Okay, so we should monitor, we should follow the rules and regulations, and also public order, and also follow the court rules, and also friendly relations with the foreign country. This is very important. Okay, those who are violating, automatically the law will be punished. And also Article 20 is very important thing. Okay, Article 20 subclass 1, 20 subclass 2, 20 subclass 3. Three provision is available. I don't want to explain more. This is very good topic because protection against conviction of the offences. Under Article 20, explain about ex post facto law. 20 subclass 2, double jeopardy. 20 subclass 3, self incrimination. What is that ex post facto law? 20 subclass 1 explain about no person shall be convicted of any offense except that meaning is except for violation of law in force at the time of the commission of the act charged as an offense, nor by subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offense. Right? And also, Article 20 subclass 2 clearly explain about double jeopardy. That definition meaning is no person shall be prosecuted and punished for the same offense more than once. Only one time only punished by the law. And Article 20, subclause 3, that meaning is self incrimination. That meaning is no person accused of any offense shall be compelled to be a witness against himself. Nobody compelled. Give witness to the witness. That meaning is confession statement. Under under Section 25 of the Confession Statement of the Indian Evidence Act, from 25 25 to 30 is available confession statement. How the confession statement is valid before the court. Okay, because the only provision is indicated Article 20 subclause 3, self-incrimination. Those who are compelled to be a witness against himself, what happened automatically? The Article 20 subclause 3 is protected to the particular individual person. Automatically, that witness is not accepted by the court. Okay, so this any sections, any act violating the constitution, what happened? The automatically court will be denying to take the evidence. Automatically, that judgment is unconstitutional. What happened? Automatically, the judge will be declared that evidence is invalid. So, in High Court and Supreme Court is very important thing to verify the Constitution. After that, only if any judgment wants to declare based on this Constitution. If any error of the Constitution is occurred at the time of judgment, what happened? The aggrieved person to appeal before the court. The appellate provision is available. Okay, and one thing I just want to share with you all: the Supreme Court is the safeguard of the Constitution. Safeguard of the Constitution. That is why Supreme Court having lawmaking power under article is given by the constitutions, right? So Article 21 is very simple: personal liberty and protection of life. Personal liberty. I have liberty to talk. I have liberty to sleep. I have liberty to silent, right? Article 19 subclass 1 also freedom of speech is one part, freedom of silence is one part, because one famous case was brought before the court, Baiju Emmanuel versus yeah, Kerala. That time, particular time, the Supreme Court also observed to the article fundamental rights. The silent also the fundamental rights only, not violated any one of the national anthem. So the national anthem case was brought before the court. The constitution is gave remedy to the particular aggrieved person. So this is a solution of the people. This is the rule of the people. This is the key word of the framers of the uh, constitution and rulers. This is the control power of the all the sovereignty of the government. Okay, and also I just want to discuss with Article 21 is a very elaborated one. Personal liberty is very term, right? If in Supreme Court gave many guidelines to the many judgments, if any one of the offender, okay, offender or any one of the criminals also came from bail, okay, bail, you know very well, or any parole category, but is offender, okay. So in this situation, that particular offender also live instead of their homes peacefully. The police officer will not disturb. Why? Because the personal liberty is given to the that particular person opportunity, right? But in outside of the area, that particular investigation team will be monitored, right? So not to disturb, that is the main provision: personal liberty and protection of life, right? Many cases available personal liberty in many in medical terminology is any one of the person wants to test the that uh, uh, any some illegal or legal relationship wants to test the some gynecological department. I don't want to explain details to you. Okay, that particular time, the girl having rights to protect their virginity and also will not disclose their medical evidence, right? So, and also Article 22 is clearly indicated arrest procedure. Based on this Article 22, only how the arrest will be happening. The procedure will be started. Supreme Court also gave guidelines to the people, guidelines to the police officer. This are as procedure: 3 hours, 6 hours, 12 hours. Within 24 hours, the police officer should produce the offender before the magistrate court. If the particular officer missing, detain the police station, or delaying to produce the magistrate beyond the limit of the 24 hours, what happened? That arrest is illegal arrest. Okay, that provision is available. Article 32 through the Supreme Court, Article 226 through the High Court, APS corpus. APS corpus meaning is produce the body before the court, right? Based on this article. So Article 22, Article 32, and Article 226 very important one, because APS corpus is available, because judicial remedy is available. APS corpus mandamus certiorari prohibition quo warranto. That meaning is, what is the meaning of APS corpus? That meaning is produce the body before the court. If any one of the person arrested by the police officer detained in the police station, or any one of the person, male or female, detained any one of the individual person custody, or kidnapped by the kidnappers, what happened? The provision is available. The the aggrieved person, relatives, or friends, or any other person to file before the court with the help of under Article 32 is the basic rights to the locus standi to the file, locus standi to file before the Supreme Court, under Article 226 before the High Court. Okay, so it's a very uh, very scope is very available, and also the enforcement of the fundamental rights. If the executive has arrested, detained any person without the authority of any law, or in contravention of the procedure established by the law, which authorizes the detention, or the law which authorizes the imprisonment if it's invalid or unconstitutional. So the High Court or the Supreme Court may issue a writ of habeas corpus against the authority which has kept in person in custody. And also writ of mandamus. What is that meaning of mandamus? Our constitution gave elaborate expression. Mandamus is a Latin term, which is meaning is command. That meaning is order. Mandamus is a judicial order issued in form of a command to any constitutional or statutory or non-statutory authority asking to carry out a public duty imposed by law, or to refrain from doing a particular act, so which the authority is not entitled to do under the law. Okay, so the writ of justice is available. So locus standi, and also you can file the writ petition is available, and also the condition is available. The mandamus, there must be a public duty on the part of the respondent. These are all grounds. Based on the grounds only, the mandamus will be applied. Such a duty must be absolute. There must be specific demand and refusal, subsisting duty. Okay, so these are all available. So mandamus may be issued by the Supreme Court and also by the High Court to the government, inferior court, or any other tribunal, or any public authority, including administrative and local bodies, corporation, or any person having public duty to perform to appropriate case. So mandamus may be issued even against the legislature, even against the legislature. For example, if the fundamental rights is violated by a competent proceeding initiated by the legislature, so the court may issue the writ against the legislature. When the High Court acts in administrative capacity, a writ of mandamus under Article 32 may be issued against it. Writ of mandamus under Article 32 from the Supreme Court under Article 226 is High Court. Okay, what the purpose of mandamus is, you know very well. The purpose is enforcement of the fundamental rights. The court will issue a writ of mandamus restraining the public officer or the government for enforcing the order or doing the act against the person whose fundamental right has been infringed. So many things available. I just wanted to uh, leave some other important things because I have some constraint time. I just want to close this video. Okay, writ of certiorari. Another thing is very word certiorari is also coming from Latin. This literally meaning is to be certified. So this writ is issued by the Supreme Court or High Court to an inferior or lower court calling upon the record of proceeding in the inferior court, okay, for the review purpose. For the review purpose, the inferior authority is directed to transmit the records to check whether the decision by the such authority is illegal or against the principle of natural justice. Okay, uh, the grounds for issuing the writ of certiorari is number one is judicial error or lack of jurisdiction. Number two, improper constitution of such authority. Number three, if such authority is incompetent. Number four, its jurisdiction is unconstitutional and violation of the principle of natural justice. You know very well natural justice, audi altum pater. That meaning is both side should be here. Okay, if one side is here and other thing not here, what happen automatically? That inquiry is not a good. Okay, that's natural justice. And and also the object the protect the fundamental rights conferred to the citizen under article under part 3. Okay, so to cast the decision of a legal authority which has to act judicially acted in excess of legal authority. Writ of prohibition, another one. Writ of prohibition, the writ of prohibition is a judicial writ issued by a superior court to the inferior or lower court or any other tribunal or any administrative authority vested with a duty to proceed judicially so as to prevent him from acting or proceeds in excess or abuse of their jurisdiction, setting aside the principles and laws of land. Okay, now the term is called, we are using stay order. Okay, so um, and the last one, writ of quo warranto. This writ also very important one because this writ is asking questions. What authority that particular person to hold office? That meaning is quo warranto, question the title as to the holder of the office. For example, any one of the person appointed by the government office, that particular person having lower mark, but the aggregate person got a high mark from the government examination, is having full capacity to appoint particular post. What happened in this situation? This aggrieved person approached the court through High Court or Supreme Court with the help of respective articles 32 and 226. What happened? Judge will order to that particular department what authority is appointed by the particular persons. This is locus standi who can file a petition for the writ. So this very important thing, and also the conditions to be satisfied. The main grounds is available. Based on these grounds only, the particular aggrieved person should be filed before the court. That the office must be a public office. The office must be substantive in nature. That meaning is permanent in character and not terminable. The person must be in actual possession of the office. The person must be have held in the office country to law. Okay, so we have many other things available under article 23, 24, 25. Okay, we didn't discuss the 23 and the 24 and 25 and all. We don't have time to discuss with. At least I should uh, elaborate the outline of the heading of the title of the constitution. Right against exploitation under article 23 and 24. Freedom of religion, how the freedoms given by the constitution to the religious people under article 25, 26, 27, and also article 29, 30, cultural and functional rights of the minorities. So these are all very important things based on this minority uh, minority religious institution also started by the peoples and NGOs, and Hindu minorities and Christian minorities and Muslim minorities. Educational institution also started by the people. So some privileges given to the people under constitutions, because I'm saying that outline only, because if I'm elaborating each and every article, the time will not enough to single video, right? That is why I'm giving outline, right? And also Article 51A is a very important one. Why? Because fundamental duties, fundamental duties. So that meaning is 10 duties, 11 duties available to abide by the Constitution and respect its ideal and institutions, national flag and national anthem, and to cherish and follow the noble ideals which inspired our national struggle for freedom, to uphold and protect the sovereignty, unity, and integrity of India, to defend the country and render national service when called upon to do, to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, and regional or sectional diversities, to renounce practices derogatory to the dignity of women, to value and preserve the rich heritage of our comprised culture, to protect and improve the natural environment, including forests, lakes, rivers, wildlife, and to have compassion for living creatures, to develop the scientific temper, humanism, and the spirits of inquiry and reform, to safeguard public property and to abjure violence, to strive towards excellence in all spheres of individual and collective activity, so that nation constantly rise to higher levels of endeavor and achievements. So, and also who is a parent or who is a guardian to provide opportunities for education to his child, as the case may be, what between the age of 6 and 14 years. That's why under 86th Amendment Act in the year of 2002 was amended. And also the main object of fundamental duty is enlighten every citizen that while enforcing fundamental rights, he must also be a conscious of his fundamental duties. So, so intelligible, capable of fulfillment, constrained through time, and constant with the official actions. So, dear viewers, and Article 51, 52, 53, up to 395 article is available. The only one article I just want to discuss the amending provision. We already utilize. I'm using that word amending power, amendments. Okay, Article 368 is a amending power is available. Based on this article, only the legislators amend the law. Okay, so and 13 is very important because the definition of law is available 13 subclause 3, because that is orders, notifications, ordinance, many other things is provision is discussed in our constitution. The definition of law also available. The notifications, orders, the president, the orders passed by the Supreme Court also considers a law. And Article 13 subclause 1 is a pre-constitutional law, that is a doctrine of eclipse given by the Supreme Court, the one of the leading case, Bikati versus Union of India. So based on this article, that is 13 subclause 1 is a pre-constitutional law. So the doctrine of eclipse is available whenever need the particular article, particular law, we can utilize. Sometimes that law is not used, diminished by the some amending provisions. So or that is that article law in force. So whenever we need particular act, we can take it. Otherwise, we cannot able to delete it by the any one of the provision. temporarily withdrawn. Whenever we need, we can utilize by the Article 13 sub clause 1. And Article 13 sub clause 2 is a doctrine of severability. That is post-constitutional law. Now we are following, right? So Article 13 sub clause 4 is given to the opportunity of the our people. Above 13 sub clause 1, 2, 3 is not a amendment. You know very well. See, the 13 is heading of the constitution is law inconsistent with the fundamental rights. Whenever the inconsistent of the fundamental rights, what happened? That inconsistent is not deleted by the legislators, temporarily denying, temporarily withdrawn, and amendment provision is applied and will give the meaning to the particular law. Okay, so this Article 13 is very important. If I am discussing with 13, 1, 2, 3 is there is no time because that article is very great one. The legislate that is a judicial review. Okay, judicial reviews available, and also constitution. The framers of the constitution committee is many persons, nearly nine persons. Okay, so the chief is Dr. Ambedkar, and also Jawaharlal Nehru, and many other things, many other peoples are available. Eman Roy and many other seniors has participated, chief drafting persons and drafting committee also available. And based on this drafting committee, only the 1935 Act is replaced by the in our present constitution. That 1935 Act is here, Article 13 sub clause 1. That is pre-constitution law. Now we are using that word. Okay. So, and another thing I just wanted to discuss in this video before I'm going to closing this video. I'm very pleasure to say we are all gifted person. Well, because we are the Indian peoples, we are sharing any one of the thoughts, express the our feelings, inner feelings freely based on in our constitution given opportunity under Article 19 subclause 1A. So nobody violating the that particular article because the leading case also brought before the court many cases. Okay, based on this article gave opportunity to give many person relieved by these provisions. Okay, so in this the main thing is the year of 2015 is marked the 125th birth anniversary day of Dr. P.R. Ambedkar, and government wanted to pay tribute by observing 26th November every year in the remembrance. So Dr. B.R. Ambedkar played a key role in drafting the constitution. So it would be worthwhile to look at his last speech on the eve of the 26th November 1949. So main thing underlying the three persistent threats to nascent democracy, and it is said that this remained relevant even after 73 of years of the independence. The first was means protest in democracy and also refer to civil disobedience, non-cooperations, and satyagraha. That meaning is bloody methods of revolutions, and cautioned that these methods are nothing but grammar or anarchy. So bhakti in religion may be a road to the salvations, but in politics, bhakti or hero worship is a sure road to degradation and eventually dictatorship. On 26th January 1950, we are going to enter into the life of contradictions. So, in politics, we will be recognizing the principle of one man, one vote, and one vote, one value in our social and economic life. We shall, by reason of our social and economic structure continue deny the principle of one man, one value, how long shall we be continue to live this life of contradictions? So we should respect the constitution and also constitution day. We should love the our nations. We should protect our constitution, and also we should protect our people. How the framers of the constitution given to our peoples. We should test it our constitution, each and every article. Then we can realize, and also we should give to the next generation to the peoples. And we should guide the people and should protect the people. We should save our country also, and also we should respect all the leaders of the constitution bodies, all the leaders, because all the leaders minds is protect the constitution, right? All the leaders of in our Indian peoples, I should respect through this video, because all the leaders are following in our Indian constitution. Based on this constitution only, all the leaders wants to give the protection to the our peoples. So we should again, I repeatedly I'm saying that we should respect all the leaders, because the leaders having headache. Why? Because to protect the people, how lead the people in right directions, how to give the awareness to the people, how protect the people, what the welfare of the people should create and to give the nations, how to grow in economically, how to build and develop the people all over the nations. We should focus. We are the people of India. We the unity and strength is very important. Jai again. Bye. Thank you.